Thank you all for being here today. Appreciate it. For joining us for our webinar titled Litigation Roundup, What Public Health Professionals Need to Know About Key Cases from 2024. We're thrilled to have you here. This is going to be a little bit different from a traditional year-end review of major cases. We're still going to cover some of the most important cases released in 2024, but we're aiming here to go beyond the basic facts and the blow-by-blow analysis of the court's opinions, and instead focus on the so what question, explaining why public health professionals need to understand these legal developments. So we'll be trading breadth a little bit for depth, and in doing so, hopefully give you more actionable information for your work. But first, a little bit more about the Public Health Law Center. We're located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. And I want to acknowledge that we're on the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in this area. We appreciate their ongoing stewardship, spiritual connections, and the lifeways that they've developed in the homelands upon which the law school sits. The Public Health Law Center offers free legal technical assistance to all communities, public health advocates, and other partners. We also publish widely on public health issues, and we offer trainings and webinars like this one. We do not, however, offer direct legal representation, nor do we lobby. At the Public Health Law Center, we prize equity above equality. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. Effective public health policies must provide benefits to everyone. Research also shows that comprehensive public health policies are best, especially those policies that consider the social determinants of health, the network of policies and factors from housing to education to the criminal justice system that impact people's health and happiness. I'm pleased to say that this is our first ever webinar being hosted specifically by the Public Health Infrastructure team here at the center. The PHI team is a new venture within the Public Health Law Center, supplementing work being done by our Commercial Tobacco Control team, our Healthy Eating and Active Living team, and our Climate Justice team. Whereas those groups focus on important substantive topics, the Public Health Infrastructure team works to provide legal and policy capacity building assistance to public health managers and other public health professionals across substantive areas. It tackles foundational legal questions about public health authority and provides training and tools so that public health professionals have the legal knowledge, skills, and abilities to advance equitable public health policies. Its core areas of work include, as I mentioned, public health authority, including questions of preemption, legal capacity, including trainings on basic legal issues as they relate to public health, intergovernmental coordination, including work on data use agreements, and equity-informed policy. One thing that the Public Health Infrastructure team shares in common with the other groups at the center is that we provide free legal technical assistance to public health professionals, and we are especially soliciting requests for TA on data use agreements. So if you have questions about those or other topics, please don't hesitate to contact us at the information provided here. We're very lucky today to be joined by my colleagues, Willow Anderson and Daniel Carpenter-Gold. Willow is a senior staff attorney with our commercial tobacco team, focusing on commercial tobacco control issues in Minnesota and with the FDA and other federal agencies. She provides legal technical assistance and works with state, tribal, and local governments to adopt sound and equitable policies that advance public health. Before joining the center, Willow was an assistant attorney general with the state of Minnesota and worked in private practice, litigating against insurance companies. Today, Willow will be drawing upon her expertise in regulatory law and discussing a trio of cases from the Supreme Court in 2024 that have redefined administrative law at a federal level. Daniel is a staff attorney with the center's Climate Justice team, where he provides legal technical assistance on climate justice issues to advocates, community groups, and local governments with a focus on equitable building decarbonization. Daniel was previously a fellow at the UCLA School of Law, and before that worked as a staff attorney at Take Root Justice in New York City, where he provided legal support to community-based organizations in the areas of housing quality and equity, land use, and economic development. Daniel's going to discuss a series of cases that his team has been carefully tracking over the past year in which industries argue that federal energy law preempts local decarbonization policies. So here's our agenda today, relatively straightforward. We're going to be beginning with Willow discussing the administrative law cases that she's been tracking before moving on to Daniel and his presentation on preemption litigation. We're going to conclude that with a moderated discussion with our panelists before ending with an audience Q&A. So if you do have questions, please do put those into the chat. I'll mention also that we're joined by Senior Staff Attorney at the Public Health Law Center, Tonya, and she'll be tracking your questions in the chat, providing answers and resources where appropriate in the meantime, and collating the rest for our panelists to end with. So with that, without further ado, I'm going to turn things over to my colleague Willow, and I will stop sharing my screen. Thanks, Willow.
Can you see my screen?
Yes, we can.
All right. Well, welcome everyone. It is really nice to be gathering with this group today. We have hundreds of talented public health professionals here on the call, and you're here, I assume, because you know how integral the law is to public health. We've seen sweeping headlines, but what has happened more quietly and very powerfully is the work of the United States Supreme Court during the last term. If we were to identify a key theme from its 2024 cases, it would be this: a significant shift of power away from administrative agencies and toward the court itself. This webinar is very big picture. We aren't talking about the curtains or the drapes. We're talking about the ship itself, the vessel that carries us, the Supreme Court of the United States. So today I'll focus on a trio of Supreme Court cases from the last term: Loper Bright, Corner-Post, and Jarchese, and their combined impact in weakening agency power. We'll also examine how these rulings directly affect, or not, state, tribal, local, and territorial public health managers. Let's get to work. I said this is going to be big picture, but to understand what happened last year at the Supreme Court, I need to tell you about the Chevron doctrine and its significance. For 40 years, this doctrine defined how courts handled agency decisions. It was so important that law students like myself and all my colleagues spent an entire semester studying just the Chevron case and its legacy. Here's how it worked. When agencies interpreted laws to create rules, say for food safety, courts followed a simple two-step process. First, is the law clear? If yes, then follow the law. If the law is unclear, is the agency's interpretation reasonable? If yes, defer to the agency's expertise. This was called Chevron deference, or the Chevron two-step. The system gave agencies predictability. They knew how courts would evaluate their decisions, which was especially important for public health work, where we often need to act and respond to emerging science and changing circumstances. But now this 40-year framework has been dramatically altered. In 2024, the Supreme Court overruled it in a case called Loper Bright versus Raimondo. Gina Raimondo was the Secretary of Commerce. On the surface, Loper Bright seemed like a straightforward dispute among fishing regulations, specifically whether commercial fishers would have to pay for monitors to observe their own catches. But there was more beneath the surface. While the case featured fishermen and fishing families as plaintiffs, yes, the lawsuit was strategically supported and funded by industries who had long sought to reduce agency authority. The court used this modest fishing dispute as an opportunity to overturn Chevron. And instead of allowing agencies to make reasonable interpretations of ambiguous laws, the court ruled that judges, not agencies, should have the final say in interpreting federal rules and regulations. Think about what this means in practical terms. You know that agencies regularly interpret laws to create public health guidance. Under Chevron, that agency expertise was generally deferred to. Now, judges who may or may not have any background in public health will have more power to second-guess agencies' technical and scientific judgments. But Loper Bright was just the beginning. Another pivotal case that creates more challenge for administrative agencies is Corner-Post versus the Board of Governors. This one deals with when people can challenge agency regulations. A statute of limitations is a time limit to bring a legal challenge. Think about it as a countdown clock. Once the clock runs out, you can't sue anymore. Statute of limitations provide finality and ensure we're not litigating decisions made decades ago. Corner-Post was a convenience store that opened in 2018. Here's the gist of the case. Since 2011, there had been a rule limiting the fees convenience stores could charge customers for credit card transactions to no more than 21 cents and 5% of the transaction. That rule was challenged and upheld in court in 2013. The statute of limitations on that rule was enacted 6 years earlier. So when Corner Post came forward in 2018, more than 7 years after the rule was upheld, you'd think that this would be a closed case. Not anymore. The Supreme Court ruled that the statute of limitations doesn't start when the rule goes into effect. Instead, it starts when each individual business or plaintiff first notices they're being harmed by the rule. The implications could be staggering. When you combine this with Loper-Bright, you can see how the court has created a perfect storm. Agencies not only lose their power to interpret regulations, but now those regulations can be challenged at any time by anyone who feels affected by them. This could create uncertainty for agencies trying to establish and enforce public health standards. The third major decision, SEC versus Jarchese, challenges how agencies can enforce their rules. Here's what's happened. The Security Exchange Commission caught George Jarchese committing securities fraud. He made false statements to investors and inflated fund values to collect higher fees. They fined him for their usual administrative fines and process. But Jarchese appealed to the Fifth Circuit, claiming that he had a right to a jury trial, and the Supreme Court of the United States agreed. Why is this a big deal? Previously, agencies could handle violations through their own administrative proceedings. These were efficient processes led by experts. But now, under Jarchese, if an agency wants to impose civil monetary penalties, the respondent conceivably has the right to go through a full jury trial at federal court. Think about what this could mean for public health enforcement. A process that once took months might now take years. This could be particularly concerning for agencies like the FDA, which rely on administrative proceedings to ensure compliance. So let's put all these three cases together. Loper-Bright says agencies can't interpret ambiguous statutes, judges need to. Corner Post says that a harm party might be able to challenge those rules that when the harm is noticed. And Jarchese says that the SAC, at least, can't enforce its rules through an administrative process without the right to a federal jury trial. In my work at the Public Health Law Center, I focus on commercial tobacco control, and we can see the immediate implications. The tobacco industry constantly introduces new nicotine products, and we've counted on the FDA's scientific expertise to protect consumers, especially youth, at the national level. But with Chevron deference gone, we face some critical questions. Will established rules face new legal challenges? Will tobacco companies gain more leverage than public health in court and by the Supreme Court? And how can we effectively regulate commercial tobacco in this new landscape? These aren't abstract concerns. They directly impact our ability to protect public health. One thing is becoming increasingly clear. Agencies will need to ground their regulatory expertise explicitly in the laws they're tasked with enforcing. The PMTA, or the pre-market tobacco product application process, is one area that could pose challenges for the FDA as it navigates in this new legal landscape. It's a process that was already rife with litigation, with many claims inherently tied to agency deference, specifically how much weight courts should give to the FDA's decisions on product authorizations. Under the Tobacco Control Act, for example, any authorized product must be deemed appropriate for the protection of public health. But now, could that phrase be increasingly open to interpretation, not just by the FDA, but also by the courts? On top of that, lawsuits stemming from the PMTA process, often brought by manufacturers whose products are denied authorization, are unlikely to see courts defer to the FDA. Instead, we're already seeing decisions that disregard the FDA's scientific judgment and side with tobacco industry. This trend is particularly evident in jurisdictions like the Fifth Circuit. Take Wages and White Lion versus the FDA, which was argued before the Supreme Court just last month. In this case, the Fifth Circuit Court of Appeals sided with the industry, ruling that updates to the FDA's guidance on what was required for PMTA applications introduced during the application process was arbitrary and capricious. The FDA, for its part, argued that it has the authority to update guidance and new data as harm emerges on the benefits and harms of tobacco products, and that the company had always had notice of the rule because it's printed in the Tobacco Control Act itself. A lively question and answer period ensued between the justices and the attorneys about court interpretations of things like protection for the public health and notice. We will keep you updated on the outcome of those cases and as that case progresses. As the new landscape settles, the FDA faces a major challenge in states' enforcement. With so many unauthorized tobacco products on the market, the requirement for a jury trial after Jarkizi could potentially slow down efforts to impose penalties and remove these products. The industry is already using these rulings to its advantage. There's a case called Huff and Puffers versus FDA. Yes, that is the real name, where the plaintiff filed in California arguing that the FDA's ability to impose civil monetary penalties under the TCA is unconstitutional, citing Jarkizi claiming that it violates their Seventh Amendment right to a jury trial. They're asking the court to block the FDA from imposing civil monetaries, and we will keep you updated on that case as well. What does this all mean for states? Most states are unlikely to be directly bound by Loper-Bright, as it only applies to federal agencies. States have their own approaches to agency deference, and they fall into several different categories. Your specific current approach to agency deference won't be changed specifically under Loper-Bright. The only way that would happen is if your state legislature or courts specifically act to remove existing agency deference. Meanwhile, states and localities remain on the front lines. In the case of commercial tobacco control, for example, states can still use a variety of tools, and that includes localities and tribal governments as well. They can still prohibit sales to underage users, update tobacco taxes, implement tobacco retail license restrictions based on location or density, impose fees and fines for unauthorized products, and limit flavored tobacco products, for example. So those local efforts continue to be crucial in preventing addiction to nicotine products. Looking ahead, federal agencies like the FDA will need to carefully ground their decision in state authority and solid research. But here's the key takeaway while we navigate this new federal landscape. While recent Supreme Court decisions may seem to limit federal administrative power, state, local, and tribal action remains crucial. Historically, it's been the local initiatives that have often sparked broader change in federal policy ultimately. The public health victories frequently begin at the community level before expanding nationally. So we are still looking to coalitions and local units of government to do its public health work, because at the end, that's ultimately how the federal government has always acted broadly on sweeping public health change. So there's a little bit about the Supreme Court in its last term, maybe more than a little bit. But I'd like to turn now to my colleague Daniel, who has a really interesting presentation on the fog litigation can cause and potential counter strategies. Thanks.
Thanks so much, Willow. And that really for a wonderful walk through some really important cases that are going to have a huge impact on public health as we move forward. I'm going to dig down a bit into the dirt to get at the roots from your last slide of some of these, where these cases come from, down in the district court level, the first court that public health cases and other cases and have to deal with in most cases. And what happens when those cases begin to proliferate, when they get all over the place, little bits and pieces of litigation that are disruptive and difficult for folks like you all in the public health space at the state and local level to deal with. We're going to talk about industry use and abuse of preemption litigation. This is based off of the experience that the Public Health Center and the Public Health Law Center, and specifically the Climate Justice team, has had in dealing, as Tom was saying at the beginning, with litigation over the preemptive effect, the preemption, meaning the state and local laws that are displaced by a federal law called the Energy Policy and Conservation Act, or EPCA. So we'll get into what that is in a second. But to begin with, I want to start with sort of a theory of how this all works. So public health practitioners, policy folks like yourself are moving along with a relatively blank slate. You have the policies that you think are best going to advance your public health goals. But every once in a while, a anti-regulatory actor, say an industry actor that doesn't like the regulations that you're proposing, is going to put out a bad legal take. That bad legal take says, oh, you can't regulate in this area, or federal law, in the case that we'll be talking about, preempts you, displaces the law that you're relying on here. Now, most of the time, these bad ideas don't go very far. They get stuck in the courts, they stop, or they get stopped even before they go to litigation. But every once in a while, through sheer random chance, let's say, a bad idea makes it through. And that creates a lot of problems for policy folks like yourselves. It creates what Willow was calling this fog of confusion around the policy space. That fog has several sources, as I'll talk about in a minute. It comes from the existence of many different follow-on litigations, so lawsuits that are brought after an initial lawsuit is successful, trying to use or expand the theory. It comes from just the confusion that the disruption to the previously understood legal paradigm can cause for folks who are trying to develop policy and don't want to have to become experts in a new set of laws just to understand what their authority for policymaking is. And it also comes from the costs that occur. So folks, state and local governments incur costs when they have to re-review the policies that they had already decided on for litigation risk or preemption risk, and especially when they have to defend those policies. So we're going to be talking about what folks like you all can do when you're in that fog of litigation, that fog of confusion. And it's especially important, your roles are especially important because that can really determine what happens as a result of that anti-regulatory pushback. So when folks are, when the anti-regulatory pushback leads to the chilling of policy, by which I mean a series of decisions that, maybe we shouldn't try and pass this policy, maybe we shouldn't enforce this, or maybe we should even withdraw something that's already established because of these new legal developments, it can be a very attractive option because we don't want to be sued and we don't want to have to deal with the confusion that results from a complicated legal landscape. But when that happens, that rewrites the status quo so that the initial idea, which had started out as a kind of out there idea outside of the normal status quo understanding, that becomes the new status quo. And the policy that you're trying to advance is no longer advanced as it's a general understanding that you don't have the authority to do it. If, on the other hand, the state and local governments really stand on their principles and stand on their policies and defend them where they can, that can actually, this fog of litigation, this wave of litigation can actually improve those policies and strengthen them because it allows, potentially allows state and local governments to make necessary amendments to protect their policies from litigation risk without dampening or removing the public health benefits of those policies. And also, that wave of litigation can lead to a wave of lawsuits. If the anti-regulatory actors are relying on new and untested legal theories, they're probably going to lose a lot. And as those losses pile up, that strengthens rather than weakens the basis for the policies. And so in that way, you can strengthen your own ability to act and to regulate in the service of public health. So I said before I'd talk about this fog of litigation and go into a couple of problems. Now, if you've been in as I'm sure many of you have, you've been in a subfield where there's been a recent change in the law, a recent new set of legal challenges, you're probably very familiar with this. The essential problem is that it's too easy to sue on these cases and it's difficult to defend. There's a low barrier to litigation, especially for well-resourced industry groups or other anti-regulatory actors. And that is lowered when they're able to essentially or literally copy paste arguments or language from one legal document to another as they file copycat litigation all over the country, which is something that we've seen in several different subject matter areas. In addition, the fact that there's some ambiguity in the law, which is created by that initial disruption to the law, means that there's attorneys will have a greater ability to bring new, radical, and untested ideas. Now, attorneys are generally pretty conservative about bringing these ideas because you're only supposed to go so far in trying to expand the law. But once there's ambiguity in the law, that strengthens the ability of attorneys to bring new ideas that are even more radical and try to break the ability and the authority of state and local governments to pass strong public health policy. And you eventually get to the specialization of attorneys eventually gets to develop like a cottage industry of one or two or more firms that specialize in bringing these cases, which then further reduces the cost and creates, a constituency pushing for more actors to bring these cases. Now, litigation is also on the flip side. Litigation on the defense is very expensive for the governments that have to defend themselves because they're coming, generally speaking, they're coming to the issue for a first time. Attorneys that are supporting governments are generally generalists rather than specialists in a particular area of law. And then the sheer number of cases, creates some chance of additional bad rulings. So overall, the effect is what we call a chilling effect. It creates an incentive not to push as hard on these policy areas, to pull back on what would otherwise be strong public health policy. But at the same time, there's a counter strategy. So coordination, mutual aid, and outside support are ways that both the state and local governments that are being challenged or potentially having this chilling effect placed on them can support themselves and others. So the first thing that we always talk about is, reach out to others. There are other governments, whether it's you're looking at a new legal development for the first time and you're trying to figure out whether that it's relevant to you, or if you've already been, encountered some kind of pushback from anti-regulatory actors, talk to other governments that are in a similar position and talk to advocates and experts who have been looking at this, because there's usually a lot of resources available for anybody who's encountering this situation, including state and local public health officials. Starting from that outreach, develop a network so that you know and can regularly communicate with people about what new information, what new developments come out, and to the extent possible, share your own analysis and see how it turns out. Share the results of the decisions that you're making. Keep in mind always that support is available. So publicly available research into public health authorities and trainings like this webinar, technical assistance for state and local governments who want to understand the scope of their authority and the risk spectrum that they're facing. And where a particular set of technical assistance or a particular set of educational materials isn't available, it's always worth asking for it, because folks like the Public Health Law Center, we're always looking for new projects that we can undertake that support our partners. So that was a broad theory. I want to talk now about what's actually been happening in the world that we live in, the climate justice team, which is the world of building decarbonization, building electrification, and related policies at the state and local level. So the development over the last year and a half has centered around the impact of a case called California Restaurant Association versus the city of Berkeley. Now, this is a case that was a challenge to a 2019 ordinance from the city of Berkeley, which would have prevented the installation of natural gas infrastructure in new buildings. Now, everybody had understood that the Energy Policy and Conservation Act, which is the federal law in which the challenge was based, was what had a limited scope of preemption. That is, that it only displaced state and local laws that would directly address appliance efficiency, not that would address the infrastructure necessary to run appliances, as the Berkeley Ordinance did. So that was this general understanding prior to this case. But this new radical idea was brought by some folks who were challenging the Berkeley Ordinance. And that idea was that the EPCA, the Energy Policy and Conservation Act, in preempting state and local appliance efficiency regulations, also preempted regulations that would affect whether those appliances were used in the first place. Now, this is a new idea. It lost at the district court level, the trial court level, but the challengers appealed it and it managed to win at the appellate court level. And what that meant is that we established there's a crack in the previously established paradigm. And now this new theory is out there in the world that we don't, that policy makers and officials hadn't had to deal with before. And on top of that, we doubt there was a lot of new litigation. Now, before I get into this, I want to touch on one quick sort of civics point, which is that when a new opinion comes out at the appellate court level, it's binding precedent for courts in that appeals court jurisdiction. And so that means that other courts, lower courts, so district courts in that appeals court jurisdiction have to follow it. But other courts, even if they're lower courts in the sense of being trial level instead of appellate level, don't have to follow it if they're not in that circuit. So this case came out of the Ninth Circuit, which is in yellow on the western side of the map here. Other cases have been brought around the country, but they don't treat the Ninth Circuit precedent as binding. They only treat it as persuasive, meaning that they can listen to the ideas in that opinion, the courts can, but the courts don't have to follow it in its entirety. In any case, the result of that one crack in the paradigm was that industry actors all over the country began to bring cases that challenged other regulations elsewhere. So this began within the Ninth Circuit, quickly followed outside of the Ninth Circuit with similar cases that were also addressing new buildings. Then it began to expand out to other types of regulation. Soon we have all over the map litigation coming and appearing. And we've now have 10 different cases that we're dealing with right now, which have come out, well, one of them was wrong, which have come out in the last year and a half. Now, this is a lot, right? It's a lot for state and local governments and officials to deal with, especially when they've got 1,000 other things. You all have 1,000 other things that you need to be thinking about. Nevertheless, there's been a very effective resistance and pushback to these anti-regulatory lawsuits, which has been, really led by state and local governments, but also supported by folks all over the country who are here to help with this sort of work. And it's followed that same process of reaching out, establishing connections, and then using those connections to inform policymaking and decisions related to this so that you don't unnecessarily pull back on your own policymaking. So the group of advocates, experts, and governments that formed around that original lawsuit, the lawsuit around the City of Berkeley Ordinance, has continued to support governments across the country, providing technical assistance to jurisdictions that want to understand the risk involved in passing their own buildings policy, monitoring legal developments like those lawsuits, and even in many cases, providing direct support by intervening in the case as a new party or by writing an amicus brief in support of challenged regulations. Ultimately, we have hope that this wave of litigation will lead to a strengthening of these policies because it will more firmly establish the legal foundation for them. And that will allow state and local governments to operate on a secure legal footing in order to establish good public health, in this case, good buildings policy. So all of these cases, these new lawsuits that have been brought out, they could lead to losses. And in any case, they're going to lead to more certainty. And certainty is always helpful when you're working in policy development. So with that, I'm going to turn it back over to Tom.
Thank you very much, Daniel. I really appreciate that interesting presentation. And as a note to myself, I have to learn from you how to do those moving graphics in PowerPoint. I think we're all learning and appreciating many things today. So now we're going to move into a moderated discussion. I've got a couple of prepared questions for our esteemed panelists here. And if it's okay, Willow, I'm going to start picking on you. So obviously you're coming at this from the perspective of an attorney who works predominantly in tobacco control. But what do the cases that you discussed mean for public health professionals more generally? Are these trio of cases starting to be cited by courts in other types of public health cases or in other types of public health domains?
That's a great question. And this is one of those areas where it's just so impressive, the amount of incredibly talented, bright professionals out there working on this, because my team and I, we were discussing, well, what are the cases, and we need to start tracking them. And then we learned about a group called Democracy Forward, who's been writing an ongoing memo. I see the last they had it updated was January 3rd, 2025. And they are tracking the cases where Loper Bright, Corner Post, and Jarkizi are being cited. The last, I don't have it pulled up right now. I think Stephanie's going to or someone's going to put it in the chat, but I think there were like 159 cites to Loper Bright and, 40. I mean, altogether, we're talking about, several hundreds of cases where these cases are now being cited. So 2024 laid the groundwork. 2025, this is the opportunity to use these cases. And it crosses all sectors. It's as Daniel talked about in the climate space, but it's aviation, it's the EPA, it's literally every corner of the federal government and all of the agencies that it affects.
Yeah, I appreciate that. Thank you. It's certainly we'll continue to track that and see how this shows up in other areas of the law. Building off of that question and your answer, though, you talked about in your presentation how state governments are going to have their own judicial standards for how they interpret state statutes and how state agencies are allowed to interpret state statutes. What does something like the Loper Bright decision really mean then at the state level? Do we perceive that as being a decision that will diffuse itself into the state level, or what are we seeing in that regard?
That's a great question, Tom. I think we need to acknowledge that this might not change anything for some states because they never had a state level Chevron doctrine or the equivalent. But similar to the logic that Daniel explained, litigants can borrow the arguments and the theories that drove the Loper Bright decision at the federal level and advance them in state courts. So you might very well get diffusion of the federal approach into states.
Gotcha. So it's a little bit of that same logic that Daniel was talking about, this diffusion of ideas across court systems, and though not technically binding, it certainly can be persuasive. I appreciate that. Thank you. My last question directed just for you, Willow, is one gets this sense when you talk about that trio of cases from 2024 that the court won't be satisfied with just a trilogy and that it might be looking to add to that series of administrative law cases. Are you following anything for this court term and for this year in particular that's happening at the Supreme Court or elsewhere?
Yeah, that's also a great question. There's no reason to think you would need to necessarily stop at those three cases. And one of the cases that our office and everyone who follows Supreme Court decisions is looking at is the case of Braidwood versus Becerra and the Federal Communications Commissioner and Consumer Rights case. This is the Braidwood case specifically addresses the Affordable Care Act's preventative services requirement, which could potentially affect preventative care benefits for millions of privately insured individuals. The plaintiffs in that case argue that the requirements may be unconstitutional under the Appointments Clause. So it's important to monitor these developments closely as they may have significant implications.
Certainly appreciate that. It's for the folks at home who aren't attorneys and didn't spend time studying things like the Appointments Clause or administrative review. This might not sound as powerful and important as some of the other high-profile cases that you're used to following in the news, but they are very impactful. It does impact, as you're discussing here, Willow, how the federal government operates and how federal programs can be delivered to folks. And so we'll be following cases like Braidwood very carefully. I believe, although I'm not as familiar with it, there's at least one other case that made it onto my radar, which is the Federal Communications Commission versus Consumers Research, which gets at the non-delegation doctrine, which is the idea that Congress cannot delegate legislative authority to federal agencies. The legislative power really belongs with Congress and not the executive branch. And when they write statutes, if they write those statutes too broadly, they might impermissibly be delegating that authority, and the statute then might be null and void. And so that doctrine has not been actively used, to my knowledge, for almost a century or more. But the Supreme Court looks ready to take that question up and potentially put some more meat on the bones of that doctrine, and we'll see what the effect is going forward. But you can imagine how that, combined with Braidwood and these other cases, really does create a significant challenge to administrative rulemaking going forward. Thanks very much, Willow. So Daniel, you talked about one of the things that I was curious about, which is that kind of civics 101. How does precedent operate in our judicial system? One thing I was wondering if you could maybe expand on, though, is what happens when one of these cases gets to the Supreme Court? What does that do to the fog of confusion that you discussed?
Yeah, and that's a really good question and important, something that a lot of folks have been talking about. So yes, there's almost the point of the Supreme Court is to provide a final decision on these ambiguous legal questions. And so that doesn't always work out because of how the Supreme Court handles these cases. But when it does work out, it does provide that level of finality. So I guess there's a couple of sort of ways to think about that. One is when you have this much litigation going on and it's eventually going to reach the Supreme Court, not a guarantee, but there's very little that can be done to change the likelihood of that. Sometimes legal strategists will talk about whether you want to pursue a particular line of argument out of a fear that will eventually reach the Supreme Court and then get an adverse ruling. But I don't think that it actually I think in this case where you've got such a broad proliferation of litigation, it doesn't usually, there's very little to be done about that. That said, there's a lot to be done about how appellate courts and the Supreme Court eventually look at the question. So it's very helpful to get a very strong foundation and understanding at the district court level, the first time that courts review this, of what the real legal issues are and what the real legal consequences are for those decisions, so that as it works its way up, it has the best possible foundation and legal understanding. And so that's why it's really important for courts, folks that are looking at how to support state and local governments to think about that initial court that each legal question is going to be addressed at, as well as the Court of Appeals and the Supreme Court. But yes, the other thing to note is that a lot of cases just don't go to the Supreme Court. It's very rare. There's a tiny percentage of cases that are that folks ask the Supreme Court to take that the Supreme Court actually takes, and that's been trending downward recently. So there's no guarantee that any given subject will actually reach the Supreme Court.
Gotcha. That makes sense. I think I've heard you in the past say, you can't win unless you play. And that seems to make sense here, where if you try to avoid litigation or not engage in it, it still might come for you and it still might make its way up. And so what I'm hearing is to some extent, one of the things that an advocate can do, or a city or a state can do, is to ensure that if it does go all the way up to the Supreme Court in that kind of rare circumstance, it goes up with the best possible record and the best possible posture. So we appreciate that. And you also talked in your presentation about how one thing that happens when you get this diffusion of cases, these copycat cases, is that the courts start to build a consensus, either one that favors the original regulatory challenge or potentially one that perhaps backfires on those plaintiffs groups and cements the previous status quo understanding of the law. I'm wondering, do you have an example maybe outside of the EPCA space in which we've seen a similar progression of cases across the country that either results in a change of the status quo or perhaps a new validation of the previous status quo?
Yeah, absolutely. So like I said, this is not the first time nor the last that industry will try and use, or any regulated group will try and use the courts to not just push forward a particular legal theory, but create the feeling that, oh, everything is getting litigated and therefore everything is potentially a bad policy. And so, it's really important in that moment of confusion to understand that just because something is being litigated doesn't mean that it's a bad policy or even that it has legal vulnerabilities. As I said before, there's very low barrier to actually suing somebody, especially on a question of regulatory authority. And so the existence of these lawsuits doesn't mean that the policies are bad. It just means that there's probably either incentive structure or a legal strategy that is leading to the proliferation of these litigation. And as a result, sometimes that incentive structure or legal strategy ends up with a stronger legal foundation for the policies that are being challenged. One of the examples is actually something that Willow is more familiar with than I am, so I may pass it to her, but the litigation against regulations of flavored commercial tobacco and how that proliferated. All these lawsuits proliferated, and then they lost. And now there's a much more stronger foundation for those policies. But Willow, I don't know if you want to expand on that.
I love that example, Daniel, because that is a great example of local jurisdictions, cities, counties, forwarding their own flavor policy, and almost at every turn litigated by the industry, and the courts resoundingly supporting local units of government to the point where I don't think we really have a successful a challenge on flavors. So while the federal government has been slow to adopt sort of broader policies, state and local and tribal authorities have successfully and been supported by their state courts and by circuit and federal courts in doing so as well. So I think that's a terrific example.
Thank you, too. I appreciate that. So that's most of the questions I had, but I know one question that a participant put in the chat earlier, actually even before the webinar began, in the forum. They were curious about what can public health advocates, folks who are working for city, states, counties, or community-based groups, what can they do to best prepare for potential litigation and challenge? We can on this webinar talk about specific risks, but is there something that folks can do to best meet these challenges so that they can advance their goals while mitigating or decreasing risk?
Yeah, I can jump in unless Daniel, as I was listening to your presentation about sort of the forum shopping and the intentional desire to cause confusion, I think more than ever, this idea of building coalitions across jurisdictions is something that public health folks can do and have done very well. But the more that there is that information sharing and adapting and monitoring to legal trends, it really strengthens the public health voice. And in some ways, the public health voice, like what is the public health voice? It's so disparate. It's so community based, and in some ways we don't have the sort of same cohesion that one company would have with a group of shareholders. We have a lot of shareholders that are interested in public health, but the more that we can communicate and monitor and adapt to those legal trends, the stronger those coalitions will be, and not just on the ground, but in preparing for legal challenges.
Yes, absolutely. What Willow said, I think, and to concretize that, if you're a public health official and you are looking at a policy and you're like, oh, I heard about X, Y, and Z lawsuit said that we can't do this anymore, then that's a great time to start asking questions and reaching out. Talk to other folks who are working on the same policies. Talk to folks like the Public Health Law Center, who we're always, we're ready to talk through these issues and help anyone in a policymaking capacity or in an advocacy capacity understand the legal landscape. And don't let the idea of potential risk invalidate the importance of the work that you're doing. Even if it sometimes feels like you're reading a lot of headlines that are really negative and it feels bad and you don't think that, and it seems like you can't do a lot, you all are among the most powerful groups in terms of creating a better, more equitable health environment for the country. And so that's, always be ready to reach out and ask for help and support each other on that.
Yeah, to that end, I think building a network of legal experts and public health advocates to support those legal defenses is going to be really important. And then just like your work always, it's building those relationships with policymakers and influencing decision makers at the local level. Those are the same relationships that you have already built. So it's never a bad time to refresh that and to have your community's public health story told.
Yeah, I appreciate that. Dovetailing on that too, sometimes the folks you should be reaching out to are already in your organization. So I always like to counsel people, do talk to your lawyers, your attorneys, if you have them, early and often in the policymaking process, so they can help issue spot potential challenges and then help you work around them and make sure that you're doing things in compliance with the law, which, as we know, is an ever-changing phenomenon. So talk to your attorneys early and often is, I feel like, never bad advice. And I say that as an attorney, so a little bit of bias there, perhaps. One other question we had in the Q&A was whether any states have tried using legislation or state constitutional amendments to enshrine Chevron-like deference in response, perhaps, to the Lower-Bright decision. And if so, if we know anything about the status of those attempts. So, Will, I'm not sure if you've been tracking that or if you have any thoughts about that sort of attempt.
I don't know of anything in particular, but that's a great question. And I actually, I'd be happy to look into that. I'm going to look into it right after this, actually. But I think it's been fairly fast. And so I'm certainly not aware of any legislative attempts because legislatures don't tend to work that quickly. But it is something that we're tracking. That's part of what Democracy Forward is tracking as well. They're frankly just doing such a stellar job at it. We're sort of relying on some of that information at this point. But definitely an interesting question and something to keep looking at.
Yeah, absolutely. And just to emphasize something you've already said before is that the Lower-Bright decision is about how federal courts interact with federal agencies in interpreting federal statutes, but that's separate from how states operate. States kind of get to decide for themselves on how state courts will interpret state statutes and state agencies' regulations that have been authorized by those statutes. So it's going to be a more complicated question that's going to be specific to your particular state. So just as a point of emphasis for folks listening. Let me see. There's another question that's kind of talking about the interplay between the themes, Daniel and Willow, of your presentations, both a kind of curtailing of federal regulatory authority while also an emphasis on federal law preempting local authority. Have either of you thought about maybe some of the forces or the logic or the ideas that perhaps connect those themes and what that means for public health going forward?
Yeah, I can jump in quickly, and then I'd love to hear what you have to say, Willow. Yeah, 100%. It's a very, it is on the one hand, potential threat to regulatory action to have both the inability for the federal government to act and the inability for state and local governments to act. But on the other hand, it points up the tension from a sort of political standpoint between the idea of anti-regulatory movement at the state and local level, and the idea of state and local rights, which has been a cornerstone of resistance to federal authority. So what I mean by that is the resistance to allowing federal agencies to take action often centers on the need for state and local governments to be able to regulate their own activities, and there's a certain democratic push to that that's hard to deny, and that's also gives me at least hope that the effort to prevent action at the state and local level is going to get a lot of pushback from that sort of more states' rights philosophy, whether that's in the judiciary or among the federal legislature who has authority over this. And so I think that there's a lot of reason for thinking that state and local policies will continue to be the place where the most important action is.
That's really well said, Daniel. The only thing that I would add is explore non-regulatory approaches, voluntary programs, public-private partnerships, and incentive to achieve public health goals. Here again, we know that without exception, the most progressive policies are not coming from regulations. They are coming from public-private partnerships and voluntary programs. So those have been our strongest levers anyway. And so just keep at those.
Yeah, for sure. And I'll just chime in as well and say, from my understanding of the Supreme Court, I wouldn't think of it as being a monolithic body or neatly following into factions. I think that the way that the individual justices approach questions like interpreting regulations and agency authority doesn't necessarily neatly correlate with how they approach questions on preemption, for example. And so I think regardless of what's happening out there in the legal ecosystem and which actors are coordinating with each other on advancing these theories at the Supreme Court, at least, I think we might see some surprising coalitions as we hear cases on things like the Dormant Commerce Clause or preemption. But we will continue to follow those. We'll continue to provide the best content that we can to help you stay abreast of those developments and so you can plan accordingly. And so we are at time. I want to thank everybody for joining us. I want to especially thank Daniel and Willow for providing such excellent informative presentations. We'll follow up, as Stephanie said, at the top of the hour with an email and a link to the recording. And if you do have further questions for us, please don't hesitate to contact us at our website. And otherwise, I hope you have a wonderful day, and thank you very much.